y'all I was gonna flood y'all, didn't I? I want to talk about something today, man. I actually made a video about this last night, but I don't think I went in like I should have went in, like cause I'm researching and studying and learning while I'm actually showing y'all what I'm seeing. So I'm not. It's like we're learning together. That's what we're doing. So sometime I may leave something out in a previous video because I didn't have an epiphany about it until after I recorded it, which is what happened to me last night. And that's why I didn't post the video that I made on this that I'm about to talk about last night. What I'm here to talk about today is letters of administration. Letters of administration. I'm going to start out just reading the definition. As y'all see, I'm on Cornell Law. It's a probate order, a probate court order appointing an administrator of a estate. Just so you know what an intestate is, it's someone who dies without a valid will. Just so you know what that is. Always click on your buttons if you don't know what these terms are. Look them up so you understand the fullness of what you read. A probate court order appointing an administrator of an intestate state. Okay. Contrast to letters testamentary, which is a probate court order approving a testamentary nomination of an executor. That is, letters of administration and letters testamentary both serve to put someone in charge of the management and distribution of a decedent's estate. Y'all know there's someone that passed away. It's a term generally used in law governing estates and trust in reference to a person who has died. Okay, that's what a decedent is. Okay, of a decedent's estate. But letters of administration refer to that appointment when a decedent dies without a will. Okay, while letters testamentary refers to the appointment when the decedent dies with a will. Okay, so that's letters of administration. Now, I spoke about briefly about letters of administration when I was speaking about rebutting the presumption of death in my previous video. As a matter of fact, let's go back to that. When I'm talking about revocation of letters upon proof of the individual is alive. Okay, I'm gonna read that one more time. Upon petition, so you got to have a petition of the missing individual. I'm gonna show y'all what missing or what they mean by missing as well. They define missing, and I think it's kind of. It can be. It's like a little. I think it's like a lot of word salad. It could be that. It could be not type of thing. Ambiguous. I'm gonna say it's kind of ambiguous. It has like an ambiguous type definition. Upon petition of the missing individual, the probate court shall revoke the letters of administration or letters testamentary at any time on due and satisfactory proof that the missing individual is in fact alive. After such revocation, all powers of the personal representative shall cease, but all receipts or disbursements of assets or other acts previously done by the personal representative shall remain valid, and the personal representative shall settle an account for the administration to the time of such revocation, and shall transfer all assets remaining to the missing individual or such individual's duly authorized agent or attorney. Okay, now let me show y'all what it says. I tell you, I had to find a 2022 version. I couldn't. They don't have one for 2023 yet. Not over here on this website. So let me see. So that's why I try to get it as updated as possible. But it says the exact same thing. Okay, I'm gonna see if I can find it where it says it defined what they mean by missing. And I'm gonna show y'all what I found. Let me go to, see if I go back to right here. No, I don't think that's it. No, that's not it. I'm gonna show you what I'm talking about. I should have just pulled that paperwork up. Missing defined. Here it is. Okay. Keep in mind, we're still in title 53, and I'm in Georgia. This is Georgia codes right here. So you gotta look your own state up. Can't be, you know, I do some other states, but today we're doing Georgia. Okay. This is for the purpose of this article, the individual is deemed to be missing if that individual is missing from the usual place of domicile, and that individual's whereabouts are unknown to those persons who are likely to know. Number 2, that individual was serving with the armed forces of the United States during any period in which a state of hostilities existed between the United States and any nation or power, and the individual has been listed as missing in action, as interned in a neutral country, or as having been captured by the enemy, or that individual whose whereabouts may or may not be known has been kidnapped or is being held hostage or otherwise detained, and is thus unable to exercise control over the management of that individual's estates. So it got different ways where you can actually you're referred to as being missing, and that's any one of these 3. If you fit anywhere in this situation, then you would be deemed missing. Okay, they will call you a missing individual. Okay, let's see. Unable to exercise control over the management of the state. Let's see it. Detained could be probably locked up somewhere. Could be detained. What they mean by detained, otherwise detained and is unable to exercise control. See, that's why I say it's kind of ambiguous. Now, me myself, I was born in a particular county in Georgia, Richmond County to be exact. But my mom left. She moved from there when I was only 1. I was 1 year old. Well, her and my father divorced when I was only 1. Put it like that. And I know shortly after that she moved to Florida. So I was missing. So that I would see Richmond County being from the usual place of domicile. That's where the estate was created. That's where the Sestake Trust was created. Will be in Richmond County. That's the same location that's written on the certificate of live birth. It's in the same county, same location. And I was missing from there for over 7 years. Here in Georgia, it says 5 years is considered missing, but the general number is 6. Some states is 4. But anyway, for the sake of talking about, for the Sestake V Act, we're going to say 7 years, okay? But I have not been there. I went there for the first time maybe 3 or 4 years ago. Since I've been an adult, since my mom left there. So, but at the same time, there still was no evidence put on their records. There was no petition filed at all in their probate court, proving that I'm still alive. You know what I'm saying? So they could still be seeing me as being missing or presumed to be dead, if that makes sense to y'all. Because according to the Sestake V Act, the Sestake V Act of 1666, we talked about it in the previous video. So this is why this has gotten my attention right here. This is why this has my attention. And and now that I'm looking deeper into it, I'm thinking a habeas corpus is not necessary for this. In the previous video, I did mention that, but I don't think it's necessary for this. That's two different processes. Because habeas corpus, for one, the petition has to be sworn. It has to be sworn. It has to be like an oath. But this particular thing, the petition, you're only required to prove that you're alive. Upon petition though, both of them need a petition. As a matter of fact, it's just like what I just read to y'all. Let's go back to it. Still alive. See, upon petition, it says letters of administration. It says due. Let's see, on at any time on due and satisfactory evidence, proof that the missing individual is still alive. It never said anything about it being under oath. And you don't have to. You don't have to do anything under oath as long as you got evidence. You don't have to do anything under oath. And I'm like, what can you use to prove that you are alive? What kind of record can you use? What is satisfactory evidence? What do they see as satisfactory evidence or proof? Let me see if they have that in their definitions right here. Let me just go back to the definitions area. Generally, you find it in general area. You see the definitions. See if they have that anywhere in here. Satisfactory evidence. Heirs, personal representative. Remember, y'all say the personal representative shall cease. His power shall cease. That's it means any administrator, with an annexed county administrator, or with a will annex. How about that? County administrator or executor. So that could be the judge, anybody that's basically, because the judge, judges are administrators too. So if you got a court case that shuts down, that will shut down his power too. Okay. Now what was I looking for? I don't see satisfactory evidence, but I can go to my Google search. Y'all see, I already looked this stuff up before. Satisfactory evidence means that the evidence which is sufficient to believe that a thing or fact is true. Okay. Satisfactory evidence is credible evidence. Okay. So now that's what that is. So back to that, what I was just showing you guys. Where is it? Still alive. Administration. I'm navigating kind of fast over here now. I let you know I'm clicking a lot. But anyway, so back to the letters of administration. I want to still talk about that. Okay. So we're going to go off into that. So now y'all see why I'm touching on the letters of administration, so you understand about this. But I'm going to go into the history first and foremost. And I found this piece of work right here. Basically, well, let me see. Hold on. Let me do something real quick. I can click off that part right there. Let's go to the definitions. Let's go to the definitions first. I found this of letters of administration. Sometimes, as you see, this is like a main definition, but this is what I found this simply by looking up administration or administrator, something like that. And these are administration of estates, and all this here, and all this. This is all is all in the class of basically what is addressing administration of estates. Now, so this is what I was looking for right here. Letters of administration. The instrument by which an administrator or administratrix is authorized by the probate court, surrogate, or other proper officer to have the charge and administration of the goods and chattel of an intestate. You remember that was when we clicked on that a minute ago. That's someone who died without a will. Okay. Notice this is 1933 Black's Law Dictionary. In the upper left hand, look at my arrow right there. Black's Law Dictionary, 3rd edition. Okay. Notice they're not saying, they're basically talking about someone who died without a will. Letters of administration. They're not talking about anyone who's actually dead. They say, well, they're not talking about anyone who's alive or could be missing, and whatever. Probably because the most likely because of the Says the KV Act in the first place. They say you're presumed dead. So if you're presumed dead, they're gonna treat you like you're dead anyway. After 7 years, they haven't heard from you. Now, let's go to the 2004. This is the 2004 Black's Law Dictionary, 8th edition. Now right here, they go to letters of administration. This is an actual definition. Letters of administration is a formal document issued by the probate court to appoint the administrator of an estate. And that's all it said as far as like the definition since we're in 2004 now, Black's Law Dictionary, 8th edition, 2004. Now this right here, this is all speaking about the history of letters of administration. That's why they say letters of administration originated in the Probate of Testaments Act of 1357. And I'm gonna come back to that part, so bookmark that in your head. Which provided that in case of intestacy, that's someone a situation where someone died without a will, the ordinary, I forgot to look this word up. I'm sure that's the title somebody's using. Oh shoot, back over here. I didn't do that. Didn't mean to anyway. An ordinary, a regular, customary, and continuing, not unusual. No, that's not what I'm looking for. Here we go. A rule or principle of a statutory. They talking about a rule. Court normally construed as the rule guides courts. This rule guides courts faced with litigation that runs in the meaning of the statute. Wonder why. I guess that's not what I was looking for either. It's a measure. Common law, one who attempts, who exempts an immediate jurisdiction in causes ecclesiastical. At common law, keep in mind when you're dealing with probate, you're dealing with equity in common law as well. Okay. Now, at common law, one who has exempt an immediate jurisdiction in cases is ecclesiastical. Ecclesiastical is dealing with the church, okay? That's dealing with the spiritual aspect of things, okay? So, anytime you see that, you're dealing with living women and men and women, okay? It's not going to be some straw man situation. Also, a bishop. Also, see, bishops are all in the Bible. And archbishops. They're all biblical, and an archbishop is an ordinary of the whole province to visit and receive appeals from inferior jurisdictions. Okay, I'm gonna pause right there. I just want to kind of give you an idea of what they mean by an ordinary. Okay, now where was I? Letters of administration originated in the Probate of Testaments Act of 1357, which provided that in the case of testamancy, the ordinary, a high-ranking ecclesiastical official within a territory, as you saw in the definition, that's in short, that's the definition, should depute the descendants' closest friends to administer the estate. A later statute, the Executors Act of 1529, keep in mind these are the time frame, 1357 and 1529, authorized the ordinary to grant administration to the surviving spouse to next of kin or both of them jointly. So this is speaking about the past, how they did it in the past, okay? And this is two different types of letters of administration right here. One is called CTA, which means got this Latin term. I forgot it's got it right in here somewhere. Cum testamento annexo. That's what CTA stands for. letters of administration appointing an administrator, come testamento annexo with will annex, letting you know is with the will with a will annexed, either because the will does not name an executor or because the named executor does not qualify. Okay, see administration come in exo under administration. If you, I can go back and show y'all what it means by to qualify. I think that was in the definitions as well. So I'm gonna back up real quick to the definitions. Real quick like. Back on up. Yeah, it should be right in here. Qualify. Here we are. Qualified means the personal representative has taken the oath, posted any required bond, and been issued letters of administration or letters testamentary as provided in this title. So obviously whoever was appointed in the will failed to meet these requirements, so he didn't qualify. He or she didn't qualify. So that's what they meant by that. Now, back to what were we? Okay, so in such case, this would be letters of administration. This would be that situation right here, CTA, letters of administration. Letters of administration, DBN, letters of administration appointing an administrator, D bonus none, meaning concerning goods not yet administered because the named executive failed to complete the estate's probate. Okay, so bottom line is these are the types of letters of administration of someone who actually did pass away. Okay, but in general, this is the definition as of the as of 2004 8th edition Black's Law Dictionary. As you see, the definition changed throughout the years, and it pretty much stayed the same since then. Here's 2009, same thing. We got the same exact definition, pretty much almost word for word. Same definition for letters of administration, 2009 Black's Law Dictionary, 9th edition. Now, I told y'all to bookmark this in your head. I went back and I found this when I went back to go look at it, and I thought I'd look at the history. And me doing that, it actually led me to this particular article. I'm sure you can find this online. It's free. It's easy to find. You gotta do is Google it. You'll find the PDF and you can read it at your leisure. I read the entire thing already, but this particular part I wanted to show to you that stood out. I just wanted to kind of point this part out right here. See right here? Say under reorganization. This is pretty much talks about the history of how the probate, how probate started. Under court reorganization, the probate jurisdiction is retained in the county courts of the state. If there is more than one branch of county court in a county, the probate jurisdiction is centered in branch 1, except Milwaukee County, where it is centered in branches 1 and 2. This is the part I want you to see right here. The judges sitting in these branches exercise the constitutional probate powers of the probate court. So this is where constitutionally protected. Keep in mind, you didn't get your rights from the Constitution, but they use the Constitution, which is like a trust indenture for any trustee that's governing the Sesticate trusts that are created, which are the public officials. They are trustees. So they took an oath to the Constitution. Okay, they have to defend it. They have to support it. So they are bound by that based on their own oaths, because once they took an oath before they got in their position, they are bound by it. Okay, so this is where you are to exercise enforcing the Constitution. It's hard for you to do it in them civil cases, and you operating as a straw man. But this is where you're going to get. This is where you're going to support. This is where you're going to get them to honor their oath. The judge sitting in these branches exercise the constitutional probate powers of the probate court. Okay. This is actually what. So I just thought I'd point that little bit out to y'all because I found this again. I found it right here. If you put this in your Google search, you'll find it. The history of the probate court. Okay. It's a Marquette Law Review, Volume 45, Issue 4, Spring 1962. Okay. Now, I wanted to point something out real quick. This also led me to finding this as well. This is called the Uniform Probate Code. Okay. I found something that was interesting in here, and I'm gonna wrap it up with this part. I just want to. It's something I found when I was looking in the. This is the table of contents right here. But I found this when I was looking in here. It was 107. Where are you? 106, 107. Right here. Evidence of death or status. Status is key, y'all. Status is key. In addition, pay attention to what you see, what I'm reading right here. In addition to the rules of evidence in courts of general jurisdiction, the following rules relating to the determination of death and status apply. Keep in mind, it's talking about death and status. Rules of evidence. Okay, rules of evidence. Keep in mind, evidence is what wins cases. Rules of evidence in general jurisdiction. Death occurs. They tell you death occurs. They talk about death, whatever. We're not talking about that because if you're watching this video, you obviously this don't apply to you. Okay, so I thought I would scroll on down to absence of death is in absence of prima facie evidence of death under paragraph 2 or 3, the fact of death may be established by clear and convincing evidence, including circumstantial evidence. Number 5 is what I want to show you right here. An individual whose death is not established under the preceding paragraphs, who is absent for a continuous period of 5 years. See, some states is 5, some is 7. Okay, for a period of 5 years during which the individual has not been heard from and whose absence is not satisfactorily explained after diligent search or inquiry, is presumed dead. Is presumed to be dead. See? It's presumed to be dead, and they're going to treat you as such. The individual's death is presumed to have occurred at the end of the period. What period are they talking about? Those 5 years right here they're talking about. 5 years. At the end of the period, unless there is sufficient evidence for determining that death occurred earlier. Now, if you got evidence that you can, they got somebody put on the record that you actually died ahead of before then that will kill all that. As far as like you actually being dead, but you're not dead. In the absence of evidence, disputing the time of death stated on the document described in paragraph 2 or 3, a document described in paragraph 2 or 3 that states the time of death 120 hours or more after the time of death of another individual. However, the time of death of another individual is determined establishes by clear convincing evidence that the individual survived the other individual by 120 hours. Number 5 is the main part I wanted y'all to understand right here. If your death it was never established, then they're gonna see you as dead if they don't have any evidence that you are alive. This is why I think it's very important for you to petition probate court of the where you were born or wherever you are, wherever you're alive, wherever you're living. I think it's important to do that. I think it'll be a good move to actually petition probate court and prove to them that you are alive, and so that they can revoke any letters of administration that they may have going on. And they can, because according to this law, it says it is revoked at that given point. Where is it? say it shall revoke. Probate court shall revoke the letters of administration or letters testamentary at any time on doing satisfactory proof that the missing individual is in fact alive. Any letters of administration, as well, those are letters there's documents basically where they got on file in probate court, where they actually appointed someone over your estate. And keep in mind when you talk about, let me touch on something about estates, so we can understand something about estates, because most people don't know the difference between estate and trust. But I'd rather show you as well. Estate. An estate is the total property, real and personal, owned by an individual prior to distribution through a trust or a will. Keep in mind, so estate is a total property. It's like everything that you own is your estate. Okay, everything that you own is your property. Okay, and what we got to understand about property is anything. Property is anything, items or attributes. I like that. Items or attribute, tangible and intangible, that can be owned by a person or entity. Okay. Property is the most complete right to something. Say property is the most complete right to something. The owner can possess, use, transfer, or dispose of it. According to California Code, California Civil Code, Section 657 and 663, the property is divided into real property and personal property. Real property consists of land and items which are immovable by law. Okay, such structures or bridges, and say like structures or bridges. How about that? Property is not, which is not real property, is personal property. Property that exists in a physical form is tangible. Is tangible property, like houses, apples, and cell phones. Property which cannot be physically held is considered intangible property, like copyrights, trademarks, or the goodwill of a company, or the goodwill of a company. Copyrights, trademarks, trade secrets, and patents are also intellectual property. If the property is held by the government or a public department, it should be listed as public property. Okay. Otherwise, it would be considered private property. Okay. Now the straw man is only public property because you haven't moved it anyway. Okay. It's held by the government because you never took control of it. So that's why it would be public property right now. But it would be private property if you put it in a trust. So I just thought I'd throw that out there. But I wanted to throw something. I want to show you something also real quick before I wrap this up. Let me see. I should have saved that thing. Let me see if I can find it. Did I bookmark that thing at all? I should have. Let me see if I can find that thing. Nah. What was that quote? It was a quote that I wrote down. I actually wrote it down at first. Something that Adam Smith had said. Let me go back. Go to my cell phone real quick. Y'all bear with me for a hot second. I gotta show y'all this before I go, so you understand. It just kind of something else that I found. What did I find? Did I download it? Yeah, I downloaded it. Yeah, I can download it. Okay. A hot second, fam. It's called. Okay. I wish I could pause this video, but I ain't gonna be able to pause it. And, I'm going there about all of my stuff, right? My stuff. My stuff. Let me see. Did I save that thing? I could have sworn I saved it. Let me see. No, I didn't, but it's in my phone right here. It's a quote that was I think it was like Adam Smith. He's basically stated where the property in which every man is. Let's see. Let me go on my Google. I'm gonna quote it. I'm gonna type the quote. Here it is. Okay. Here's it. Adam Smith right here. Read this right here. The problem, the property which every man has in his own labor, as it is the original foundation of all other property. See, your labor is your property. Just you working, what you're able to do with your hands is also your property. Your labor is not tangible. It's not something you can actually see. You know what I'm saying? But your labor is your property. That's why we're the one that put the energy behind all the contracts. That's why we are the creditors and not the lenders. Not the borrowers. We are the lenders, not the borrowers. Even the scriptures say that. So it is the most sacred and invaluable. Did I say that right? Invaluable. Okay. The patrimony of a poor man lies in the strength and dexterity of his hands, and to hinder him from employing his strength and dexterity in what manners he thinks proper without injury to his neighbor is a plain violation of his most sacred property. Okay, I just thought I'd kind of throw that out there. Okay, you can read that. You can find this on your own. You can screenshot it. But that's it. This was also used in a. I ain't gonna even say that because I haven't found it. But this one guy was on TikTok and he was saying that it was used in a Supreme Court case. But anyway, I looked for the Supreme Court case. I found that the case does exist, but I didn't find the quote in there. So, but I do see that it is a famous quote by Adam Smith. But you see that your labor is also property. So it makes sense. It makes sense that that it will be a part of your estate as well. Okay, why wouldn't you want to have full control of your labor? Things that you use to make money. It's the way you make a living. You make a living with your hands, with your abilities, with your gifts, things that your Creator granted you when He granted you life. He gave you the ability to cultivate, and so you have every right to be able to control that. If you don't control it, somebody else will. If you haven't liked and subscribed, please take the time to do so right now. And I guess my mind is going like it's constantly going, y'all. It's constantly going. So I'm gonna be making videos like a mug. So y'all make sure y'all are hitting that bell so that you get a notification every time I drop something, and you see exactly what you get it right away. And that's pretty much it. I'm gonna go on and get on off of here, y'all. And I will catch y'all in the next video. Emerald signing out.